Thank you, viewers. I take this opportunity again to welcome you to our evening class. Today, we shall be looking at the law of agency. This is a very important topic for the students who are taking accounts, diploma, and even those who will be pursuing the CPA, that is intermediate, the foundation class. So this evening, I would like to introduce the law of agency. So we shall start by defining an agent. An agent is simply any person employed by a third party in the dealings of a business. And the third party person in law, we say he is the principal. However, these two people have to agree. In law, we say their minds must be at either, because two people cannot work together unless they agree. So that one creating a relationship between two people, and therefore we call the law of agency. There are various ways through which the agency relationship may be created. Number one, an agency relationship may be created by agreement. Number two, the relationship can also be created by ratification. Number three, it can be created by estoppel, or what we call the doctrine of estoppel. Then number four, by necessity. Then the number five, we call it presumption, or what we call the cohabitation. Those are the five ways through which agency relationship has to be created. So we can start by explaining number one, agency by agreement. This is the relationship where the parties involved must to create it, and therefore their mind must be at idem. Idem means they should have the same mind. The both parties must have what we call the requisite capacity, so that this relationship can be able to continue. This means that the capacity of the two people, one who is the principal, and number two who is the agent, they must agree on the same purpose. Then we have number two, agents by ratification. Agents by ratification occurs when there is what we call an adoption or confirmation by a party of a contract, which is giving an opportunity for the third party to transact on behalf of the second party. This relationship or this agency of what we call ratification, it only occurs when one person has acted. This means he is not the agent himself, but he has just acted on behalf of the main agent, and therefore creating the relationship to exist between these two parties. However, this relationship of what we call ratification can only occur or can only arise in the following conditions. Number one, the agent must have purported to act. This now gives rise to the relationship. Number two, the agent must have had a competent principal, i.e., one who has what we call juristic person, or who has the juristic responsibility to become the principal, then making this contract to exist. Number three, the transaction entered into the agent must be capable of ratification. This one means the relationship should not be void, or their relationship should not be void, because anything that is void, it is declared null at the end of the contract. Therefore, this contract cannot continue. Then number five, the principal himself must ratify the whole transaction within a reasonable time. And in law, it is normally 14 days, 14 working days. If he can be able to ratify that, then the contract cannot be able to continue. Number five, the principal must have been aware of the material fact affecting the transaction. He must have the material fact that are affecting the transaction. Therefore, this contract or this relationship can be ratified. And lastly, the principal must ratify the contract in its entirely. So those are the various ways through which ratification can arise under the law of contract. Or conduct represent the third party, and therefore allowing this contract to be ratified in its entirely. However, there are various reasons, or what we call the requirements, for this agency by to arise. Number one, the representation should be by the word of mouth or conduct by the third party. Then number two, whether we have what we call change can rise to that estoppel to arise. Number four, we have agency by necessity. This is the fourth way through which agency relationship can be created. And it means this is where agency relationships created where there are certain circumstances where the third party or the agent cannot have that position to act, and therefore he represents the third party in the acting capacity. Maybe during the way something second party to perform his duties. Therefore, the third party is allowed to come in so that this contract can be able to continue. So that one you can say that it has been created by necessity. However, for these agents to arise, the following conditions must be necessary. The following conditions must be necessary. Number one, there must be a genuine reason or something we can call it emergency, necessitating the third party to act on behalf of the principal. Therefore, this agency can be able to continue. Then number three, the party in possession must act in good faith. This means that there should not be any malice whatsoever in their transaction. He must act in good faith, therefore necessitating this type of contract to be able to continue. Then number five, we can have what we call agency by presumption or cohabitation. This is a contract where it normally affects people who live together as husband and wife.